All rise. The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court from recess now sitting.
Please be seated. Good morning. I apologize that we're a little late. We met with some pre-law students from Fort Hays State, and as we have a tendency to do, we talk more than we should have. So I apologize that, and thank you for your patience with us. At this point, I would like ask Mr. Doug Shima, the clerk of the Kansas Appellate Court, to please call the 10:30 docket.
The 10:30 a.m. docket for Thursday, March 28th, 2024 consists of one case, appeal number 124913, Patricia Nicholson individually and on behalf of the heirs at law of Mark Nicholson versus Ava Marie Mercer and Key Insurance Company, Leavenworth County, briefs both sides.
May it please the court. Good morning. My name is James Maloney. I'm here on behalf of Appellant Key Insurance Company, along with my co-counsel, Jim Oliver, present and ready for argument.
May it please the court, Dustin Van Dyke, along with co-counsel LJ Leatherman, on behalf of appellee Patricia Nicholson, present and ready for argument.
Your Honor, that concludes our docket for today.
Ask counsel to please come forward in 124913. Council moves forward. I will explain to those who are watching our live stream or in the courtroom that we do have an empty chair on this case. Justice Dan Biles has recused from hearing this matter. What that means is that he will not participate in the oral argument today, nor will he be involved in any discussions of the case or excuse me, or in the drafting or writing of the decision. That. Counsel, please come forward when you're ready.
May it please the court, James Maloney on behalf of Appellant Key Insurance Company. With the court's permission, I'd like to reserve 3 minutes for rebuttal.
Granted.
Reviewing the briefs and the case law that touch on the issues here, I actually think this is a simpler case than the briefs may let on. In particular, I think this court has decided the issues that are in front of it today already. We can start with 2 decisions by this court, one in Ray versus Caudill and one in Americold. That's the third Americold case from 2011. In both of those cases, the court was dealing with garnishment actions where a plaintiff had obtained a judgment and was attempting to assert the judgment debtor's claim against an insurance company, or at least in theory. And in both of those cases, the court determined that this was in fact an issue of subject matter jurisdiction. In Ray, the court first found that the claim that the judgment creditor was attempting to pursue in garnishment did not belong to the judgment debtor, but belonged to the judgment creditor. And the court determined that the appropriate remedy was dismissal for lack of jurisdiction. Similarly, in Americold, the court held, in Americold 3, the court held that because there was no indebtedness from the insurance company to the insured, which was the judgment debtor, that the district court lacked subject matter jurisdiction to continue in the case, specifically saying the court lacked subject matter jurisdiction to grant plaintiff's judgment against the insurer in a garnishment action. Those are both decisions by this court, making it clear that yes, what we are here today on is a question of jurisdiction, specifically subject matter jurisdiction. This court has also decided that when the claim sought to be pursued in a garnishment action does not belong to the judgment creditor, or excuse me, to the judgment debtor, that the garnishment cannot stand. That is what leads to the lack of jurisdiction. That was the result in Ray versus Caudill, which is this court's decision from 1999. There have been attempts in the briefs to distinguish that case, and in fact, by the Court of Appeals to distinguish that case, because that case dealt with underinsured motorist coverage or uninsured motorist coverage, whereas this case deals with liability insurance. And while certainly those are different types of coverages, I think that's a distinction without a difference for the purposes we're here before the court on today. Under either scenario, the claim that is sought to be pursued does not belong to the judgment debtor. In Ray versus Caudill, the claim did not belong to the judgment debtor because it never did. It was always the plaintiff / judgment creditor's claim. And so because it was her claim and it was not the judgment.
Let me ask you, but the very claim itself is a claim that arises between a two-party contract between the insured and the insurer, correct?
The uninsured motorist claim, correct.
Correct. So it still is an insured's claim. It's just the benefits of that cause of action, or what maybe we could call it a choose in action, has been assigned, right? But there are still ownership interests that the insured still has under the policy and the cause of action. There's still that party that has the right to, that gave rise to the cause of action.
In the uninsured motorist situation, it was the plaintiff herself who was the insured and always owned that cause of action. In our situation, the cause of action originally would have been owned by Ava Mercer, who was the insured and became the judgment debtor, but she assigned that entire cause of action to the plaintiff, Ms. Nicholson.
Did she assign the entire action, or was there just a covenant not to execute?
That's a good question. I'm glad you asked it, Your Honor, because there was actually both. And I think there has been an attempt in the briefing to conflate the two. There was a document entitled Covenant Not to Execute and Assignment, or Contract to Limit Recovery and Assignment. And it actually included both. Within that document, the agreement entered into between Ms. Nicholson and Ms. Mercer, there was a covenant not to execute, where Ms. Nicholson promised Ms. Mercer that if she obtained a judgment, she would not try to collect that judgment from Ms. Mercer's personal assets. In addition, there was an assignment by Ms. Mercer to Ms. Nicholson of any and all claims and causes of action she had against Key Insurance Company. So there was both. And I think recognizing that there are two different things happening here, one, a covenant not to execute, and two, an assignment, is critical. Because, for example, the Glenn versus Fleming case, which is cited all over the briefs, that case looked at the effect of a covenant not to execute and what that meant in a garnishment action against the insured. And what it decided was, even though the insured does not have to pay this judgment because of the covenant not to execute, we're going to apply what's called the judgment rule and find that that does not preclude recovery against the insurance company. What the court did not do in Glenn was examine the effect of the assignment on jurisdiction in the garnishment. And the assignment, although contained within the same document, is in fact separate from and different from a covenant not to execute. The assignment passed ownership from Ms. Mercer to Ms. Nicholson, and that's ownership of the cause of action against Key.
What cause of action?
In any cause of action for breach of contract or negligence or bad faith, breach of what this court has described as the duty of reasonable care and good faith in handling claims against the insured.
But in the contract between Key and the insured, that's where those duties arise, right? And so those duties are still owed to the insured, correct?
If we're going to be hyper technical, yes, they arise from a contract, but this court has implied duties into the contract.
Correct.
And while those duties I think would flow to Ms. Mercer if there was continued litigation on this. The cause of action, which is what the garnishment purports to attach, has been assigned, essentially sold or transferred to Ms. Nicholson. And so in the garnishment, there has to be attachment of something. It could be, not necessarily this case, but it could be attachment of a bank account or a note, whatever it might be, some indebtedness. In this case,
Yeah, I think I understand that argument. I guess I'm wondering, why isn't the attachment to the contractual rights of the insured?
Well, because the insured assigned her right to sue. She assigned that cause of action. And that is what Ms. Nicholson purported to attach, or what the district court purported to attach in this garnishment, was not just an insurance policy. It's a cause of action.
Right,
which-
but does the garnishment statute, it covers, it attaches to intangible property belonging to, right, which I understand your assignment argument, but also owing the judgment debtor. And any rights that might be asserted by an assignee would they not just be exercising those rights owed the judgment debtor under the insurance contract?
No, I don't think so, because
Yeah, tell me why that's
the
wrong.
indebtedness here, you mentioned indebtedness. The indebtedness, if any, would be on that cause of action for negligence or bad faith in the handling of the underlying claim. The only person in the world who can pursue that claim is Ms. Nicholson. And she can pursue that claim on a breach of contract action because she has that assignment. There was nothing to it, because it had been assigned, there was nothing that Ava Mercer had that could be attached by the district court in the garnishment action. There was no cause of action that could be attached because it had already been assigned. There was no indebtedness because any indebtedness would be on the cause of action. Everything that we're dealing with in the garnishment before the district court in this case was in fact assigned by Ms. Mercer to Ms. Nicholson. And because of that, there was nothing that the district court could attach, because it can only attach property of or indebtedness to the judgment debtor, which is what this court found in Ray versus Caudill. It's what this court concluded in the Americold case.
Are you equating it then to a quitclaim deed that you would have with regard to real estate?
Quite frankly, Your Honor, I don't have much experience with quitclaim deeds, so I'm not sure I can buy into or reject that analogy. I think what I'm equating it to is simply there is ownership. Let's say there's a bank account, and let's say that bank account was owned by Ava Mercer, and the bank allowed her to say, I'm passing ownership of this bank account to Ms. Nicholson. Ms. Nicholson could not then go attach that bank account in garnishment because it's no longer property of Ava Mercer. I would make that analogy. I don't know if that's the same as your quitclaim deed analogy, but I'm doing the best I can to address it without having much experience.
Well, let's say
in
it's a
that
bundle
realm.
of sticks.
Mhm.
Sometimes use that in property class. So you've got this bundle of sticks, has a bunch of sticks in it. And if Ava Mercer kept one of those sticks, I mean, there were lots of things that she had through that policy. She had the right to get primary coverage. There was a potential cause of action for bad faith if they didn't negotiate correctly. Several rights, each one of those rights imagined to be a stick. So she's got a bundle through that insurance policy. What's your best argument that she kept no stick? She took this bundle of sticks and she gave it all to Patricia Nicholson. Whatever it is, you've got it. I no longer have anything. What's your best argument? She did not keep a stick. And if she did keep a stick, what was the stick?
I don't think she kept a stick, Your Honor. I think the document that was agreed upon by Ms. Nicholson and Ms. Mercer assigned all causes of action, all rights, all claims against Key Insurance Company.
I don't, do you know where that is in the record? The actual assignment? I'm sorry, I don't want to interrupt it.
Your Honor, I don't have it in front of me
Okay.
right now, but I maybe
It's fine.
perhaps I could find it.
It's fine.
Okay.
Please respond to Justice Wilson. I'm sorry.
Yes, the assignment passed all claims, all rights to Ms. Nicholson. And that was consideration for the agreement that Ms. Mercer got in exchange, which was Ms. Nicholson saying, I'm not going to try to collect a judgment against you. And that's because Ms. Nicholson wanted to try to collect that judgment from Key Insurance Company.
This assignment happened before the judgment was entered originally.
That's correct.
That's different from Glenn v. Fleming.
That
right?
is different from Glenn.
Is that significant? If so, why?
Your Honor, I don't think it's necessarily significant to the issue of subject matter jurisdiction. I do think it's significant in the sense that when an insured enters a deal like this and agrees that they're not going to be on the hook and that they're not going to put on a defense, and they do that before trial, that changes the outcome of that trial. Whereas in Glenn versus Fleming, that agreement was entered after the trial had already been happened. The liability and damages had been determined while the insured still had a stake in the game, while they still had a dog in the fight. And so I do think it's significant to how an underlying case is decided and how it's resolved, and whether then there has to be a test to make sure it's reasonable. But as to the question we have asked this court to review, the primary question we have asked the court to review of subject matter jurisdiction, I don't think the timing of the agreement being before trial rather than after trial makes a difference.
And Key's not a party to the assignment agreement. That's for certain, right?
Yes, Key is not a party to the assignment. The assignment was that whole agreement was made over Key's objection.
So any duties that may arise under that insurance contract are between Key and Mercer.
Originally, and now having been
Well,
assigned to,
Purely from a contractual perspective, those duties are between those two parties, correct?
yes, the duty that was owed was Key to Ava Mercer.
Correct. And does that matter in assessing whether or not there's still intangible property owing to the judgment debtor?
No, I don't think so, because it was alleged that there was a breach of that duty that Your Honor mentioned. The only way to convert that breach of a duty into recovery is through the assertion of a cause of action. That cause of action is the property or indebtedness that was transferred to Ms. Nicholson and then was no longer the property of or indebtedness to Ms. Mercer, and therefore could not have been attached in the garnishment action.
So under your reading of the garnishment statute, the assignee would have to bring a direct cause of action against Key.
Exactly. Cause
You
of
have no
action.
dispute that that would be a viable claim under your interpretation of statute, just that there's no jurisdiction in garnishment.
Yeah, and in fact, when we look at the cases, that's what we see, even after Glenn versus Fleming. There's a number of cases where there is a garnishment and there has been no assignment. There's a few cases where there has been an assignment, and in those cases, typically the plaintiff will sue directly under Chapter 60 for breach of contract.
And what language in the statute particularly would you point to that supports the rule you're claiming? Which, as I read it, comes primarily out of case law, which says that an assignee can't obtain a garnishment because there's no longer jurisdiction.
Yes, the statute that I think I would start with would be 60-732, which describes what a district court has the power to attach in garnishment.
And it's, correct me if I'm wrong, but as I have it right here, I'm looking at it, it's the property belonging to the judgment debtor.
That's correct. Or indebtedness owing to the judgment.
And is
debtor.
that the statutory language? In other words, I guess the heart of my question here is why isn't is it Nichols or Nicholson?
Ms. Nicholson,
Why isn't Ms. Nicholson the judgment debtor?
because there's no judgment against Ms. Nicholson. Ms. Nicholson attained a judgment against Ava Mercer. Ms. Nicholson is the judgment creditor attempting through garnishment.
What was, Mercer was the judgment debtor, right?
That's correct.
And she made an assignment. So why doesn't Nicholson stand in the shoes of Mercer? In other words, am I just way oversimplifying this? When you make an assignment, one person substitutes for another person, stands in the shoes of.
That's right. And that's why Ms. Nicholson could have simply filed a direct civil action. She could have commenced a civil action under Chapter 60 for breach of contract.
Because she stands in Ms. Mercer's shoes.
Or yes.
Why
that-
doesn't she stand in Ms. Mercer's shoes as the judgment debtor?
Well, if she that's a good question. If she stands in Ms. Mercer's shoes as the judgment debtor, that gets to the other prong of our argument that hasn't been the focus of most of the briefing, but that gets to the standing issue, which is if she's standing in Ms. Mercer's shoes, Ms. Mercer has no claim against Key Insurance Company because she assigned that to Ms. Nicholson. So if all she can do in garnishment is stand in Ms. Mercer's shoes, she can only assert what Ms. Mercer could assert. And because Ms. Mercer assigned her claims, she has no claim to assert against Key.
Okay. Would you at least agree that if there had been no assignment and Ms. Mercer was pursuing this garnishment, there would be subject matter jurisdiction?
If there had been no assignment and if everything else was the same in this case and there was no assignment such that Ms. Mercer still owned that cause of action, I would agree.
But how would that work? What right would a plaintiff have against a judgment creditor at that point to exercise under the third-party contract? They have not a third-party beneficiary absent an assignment.
Yes, it would not be proceeding as a third-party beneficiary. Rather, if there's no assignment, that means Ms. Mercer still owns the cause of action. If she still owns the cause of action, then it can be attached in garnishment. And through the garnishment statutes, the courts have determined that once that cause of action is able to be attached and is attached, then the plaintiff / judgment creditor can assert that cause of action against the garnishee.
Okay, so but I guess I'm confused of, but for an assignment, what right does the judgment creditor have to even, I don't know, how do you identify whether a cause of action even exists? I guess through being involved in the discovery process, but legally, you're just saying that you don't need an assignment to attach to an insurance policy and garnishment.
I think that's an accurate statement of the law, Your Honor. You can take an assignment and sue directly, or you don't need an assignment, in which case you can proceed through garnishment.
But what Patricia Nicholson got out of the assignment is that Mercer wasn't going to defend the case anymore.
That's part of it, yes.
And Mercer didn't have to worry about Nicholson anymore trying to get any money from him.
That's right. Yes, that's the agreement they made, and as part of it, the cause of action was assigned, which gave Ms. Nicholson the right, had she chosen to simply file suit to commence a civil action under Chapter 60, as opposed to proceeding through
Well,
garnishment.
why doesn't that include the right to enforce the contractual obligation?
The assignment?
Yes.
I think it does, and the right to enforce that contractual obligation would be through a direct civil action for breach of contract.
Given those answers, I'm confused about your answer some time back to Justice Wilson's question about whether or not the Glenn distinction is, the distinction of Glenn having judgment before assignment wasn't important. As I understood what you said, it made no difference. But it seems now that some of the answers you've more recently given would be talking about a difference between assignment of a cause of action as opposed to this assignment where you have a known judgment and you're just collecting on the judgment.
There's been no assignment of the judgment. It was simply the assignment of causes of action against Key Insurance Company.
There's no judgment debtor before judgment's entered.
That's right.
But it does make a difference, I think. Anyway, okay.
Still, I think as to jurisdiction, whether the assignment happens first or second compared to the trial, once it's been assigned, I don't think there's any way that there can be garnishment jurisdiction because there's no cause of action of the judgment debtor that can be attached.
So, so I did find it in here. And it's, all what hereby agrees to assign all the claims. But they're pursuing the claims, but if they win, then what happens to the judgment? Where does the money go if they win on the claims?
If I understand the hypothetical, it is Ms. Nicholson has an assignment of causes of action against Key.
Right.
If she were to then file or commits a civil action against Key for breach of contract, and if she was to win on the merits, then what she would get is a judgment against Key Insurance Company that Key would then be liable to pay.
But isn't even under that scenario, assigning that right to be able to sue hereby agrees to assign all claims. How does that make it so that, where is it in this contract that Mercer couldn't do that, couldn't pursue a claim? An assignment, but I mean, where does it say, okay, I've assigned this, but now I can't pursue it either?
Because that's the nature of assignments under the law, is once it's assigned, it passes ownership to the assignee. So once the claim has been assigned, it can then be asserted by Ms. Nicholson. It can no longer be asserted by Ms. Mercer.
So is that common law or is that a statute? What is that?
That's common law.
What if Mercer sued Key directly
If she
for breach of contract?
she commences, hypothetically, she commences a new lawsuit and says, Key, you breached your contract.
Yeah.
I think the response would be, you have no standing to pursue this because you have assigned that cause of action to Ms.
How would
Nicholson.
he even know that that happened?
Well, in this case, we have a copy of the contract because it was provided to us. But certainly, that would be something that if Ms. Mercer filed a suit and we have no idea there's been any assignment, we're probably going to be asking questions in discovery such as, are there any contracts between you and the people in the underlying case, to try to learn whether there has been an assignment.
And so your position is that there's case law out there that says if Ms. Mercer has assigned it, she no longer. Can you tell me what case?
Yeah, well, one such case is this court's decision in Nelson versus Bula. That goes all the way back to 1971. And I have a quote here that may get to what Your Honor is mentioning. It is settled law that property validly transferred or assigned by a defendant cannot thereafter be reached by garnishment. This is a necessary consequence.
But I'm not talking about garnishment. I'm talking about, can Ms. Mercer sue Key
No, she
for
cannot.
bad faith?
No, not having assigned the claim to someone.
Right, and that's the case I'm looking for.
Right. I don't know that I have that specific in front of me. What the Nelson court continued was saying that once there's an assignment, the garnishment can't happen because it only reaches property that belongs to the defendant. Well, the necessary implication there is that once there's been an assignment of a claim, it no longer belongs to the person who assigned it.
Right, but Nicholson doesn't own the money until she prevails in a separate lawsuit.
She owns the cause of action to pursue the claim to recover that money.
So see, I don't see where that's the case I want, that says that, yeah, she's a, it seems like she would be a co-owner. I don't see how the fact that it was assigned deprives Ms. Mercer of also pursuing that.
Perhaps this is, I've got notes of a few other cases here that may be helpful.
Okay.
In Curo Enterprises, which was a Court of Appeals case, which is cited in the briefing, the court said this: an assignment passes all of assigner's title as interest to assignee and divests assigner of all right of control over the subject matter. I think that's what Your Honor is getting at
Yeah.
is the
Can you give
question.
me the site for that?
Yes, well, it's in the brief, the
Oh,
case is
okay.
Curo Enterprises. I could find
Can you
it. when I
spell Cura?
Curo.
Okay, right. Okay, thank you. That's what I was getting at. Thanks.
I see my time has been expired for quite a while now. Unless the court has other questions, I'll reserve the rest of my time for rebuttal.
Thank you.
May it please the court, Dustin Van Dyke on behalf of the appellee Patricia Nicholson. In listening to counsel's argument, I realized a couple of things. The first of which is I actually agree with him. I think this is simpler than it's been made. And I think that the Americold case is dispositive. I first of all think it's simpler than it's been made because I don't believe this case should be decided on jurisdictional grounds because I believe our statutes are very clear that jurisdiction exists in garnishment here. And the statutes that I would rely upon for that proposition are 6738 and 6721 primarily. Those statutes provide that when a garnishment order is initiated, first of all, the garnishee needs to file an answer and say whether they owe whether they hold the money or not. And then the judgment creditor or judgment debtor, if they get the response, we don't hold any money, can file a reply and a hearing can be set. 6721 provides that the court is allowed then thereafter to hold a hearing and rule on whether they hold that money. The specific language of the statute is determine the rights and liabilities of the parties in garnishment. If that is not subject matter jurisdiction, I don't know what is.
Can you answer my question with regard to the bundle of sticks that Mercer owned, a bundle of sticks as a result of her contract with Key?
Absolutely.
So when that contract of assignment and can't remember what all it was called. She has this bundle. She gave most or all of the sticks to Patricia Nicholson. Did Mercer keep a stick? If so, what was it and what did it have value?
Absolutely. The stick that Mercer kept, and it's what's important about making a distinction between the Ray case that they cite as they believe to be dispositive in this case, is her liability policy never owed her a nickel. Her liability policy provides specifically, we will pay for damages for which you become legally liable. And that's the case irrespective of any covenant. They pay those damages to the plaintiff that obtains the judgment. That right was not conveyed with the assignment of rights because it couldn't be because she never had the right to receive anything. But she still had an intangible property interest in the judgment being paid.
Is that an illusory right since you have given up your right to collect against her?
No, I don't think so. And I don't think so because of what this court said in Americold 3. And getting to what the argument was, counsel, and I'll answer your question, Your Honor. Counsel asserted that Americold stands for the proposition that the covenant somehow defeats jurisdiction. That's not what the court said in Americold 3. The issue in that case was whether the dormancy and reviver statutes had caused the judgments to be extinguished because that case had been going on for 20 years. And this court held specifically that the private agreement, because the plaintiffs in that case came forward and said, no, wait, we have a covenant not to execute, so we didn't have to file a renewal. And this court said that private agreement may be enforceable by the debtor, but does not automatically destroy a district court subject matter jurisdiction. And so it's the opposite side of the same coin. Its existence does nothing to destroy subject matter jurisdiction. And to answer your Honor's question, it's not an illusory right because as this court held in Americold 3, we could still execute on Miss Mercer's assets. That's what the court held and she could sue us for that, but we could. So it's absolutely not an illusory right.
Let me ask you then, I understand your subject matter jurisdiction argument statutorily, and it makes sense that, well, like, the court has to decide whether or not there's a party who has a right to attach property that's alleged in the petition. But as I understand their argument, maybe the jurisdictional angle is more standing because of the assignment. But what I'm hearing in your argument, and I just want to explore that a little bit further, is that, yes, the assignment may have given you a right to stand in her shoes to assert the cause of action, but it didn't assign the contractual right of indemnity under the insurance contract. And that right is what you need to attach in order to actually levy payment under the insurance policy.
I believe that's correct, Your Honor.
Okay, all right.
In turning to some of the case.
Can I stop you and maybe ask what might be a really dumb question? I'm nervous about asking this question. Why does it matter that to your position, that Ms. Mercer obtained some property or have retained some form of property, whether it be a contract right or whatever it is?
I think it dispels their argument that there's nothing to attach in garnishment as it relates to a jurisdictional issue. I don't believe that that is.
Well, this may be why this is a dangerous question, reveal my ignorance here. What you're trying to attach is in Key's possession, right?
That's correct.
So why does what Ms. Mercer has or doesn't have matter?
I'm not sure that it does, other than, again, to dispel what I've heard from the other side, which is they don't hold anything that's hers.
Can I make a really simple, I'm trying to just understand conceptually how you frame the case. So you tell me whether what I'm about to say is wrong or not.
Okay.
As I understand it, you represent Ms. Nicholson. Your argument is Key Insurance has property that belongs to Ms. Mercer. Ms. Mercer assigned all those rights to that property to us. We stand in her shoes and we want to enforce our rights to that property.
I believe that's correct.
Okay.
The cases that have been cited, and I want to talk about, counsel cited Nelson v. Bula, and I think this is all interrelated from this standpoint. They rely on a number of cases for the proposition that there's not subject matter jurisdiction when the court in those cases specifically decided the issue. A court without subject matter jurisdiction can do nothing but say we do not have subject matter jurisdiction. Nelson v. Bula, that counsel just got up and talked about, was a case involving an assignment. And the court in that case said, because the claim was assigned, the garnishee does not owe the money. It didn't say we can't decide the issue. The same applies in the Chatterton v. Clayton and LSF franchise cases that they've relied upon for that proposition. And that goes back to this court's decision in Americold. What the court said in Americold 3 is it's the judgment that creates jurisdiction and garnishment. That's consistent with, by the way, our garnishment statutes. If we look at 6721, that says you can obtain an order for garnishment anytime within 14 days, after 14 days of an entry of judgment. So it doesn't support their position, because the court in deciding the case, by definition, there's jurisdiction. What this really is here, and I believe absolutely there's something to attach, and we've discussed that, but what this really is here is an end around, because it wasn't raised until we got to the appellate level. This was never brought up. They never asserted that the assignment did anything to divest the court of jurisdiction until we got here. If anything, what's being raised here is a defense, and it's a defense that should have been litigated in the answer and in the underlying garnishment, but it wasn't. And because it wasn't, it should be waived by this court.
Except it's jurisdictional, which isn't really subject to waiver.
Well, I agree, but Your Honor, for the reasons that I stated, the statutes as well as what I believe to be the controlling case law, I don't think that's the case. I want to address a couple of things that counsel mentioned. Again, I stated already that the Americold issue was based upon the lack of judgment, not the covenant not to execute, which is not the case here. But I do want to talk about this concept of covenants not to execute, and this kind of fiction, I believe, that's been created that in this type of litigation, there is ever a covenant not to execute that exists without an assignment. It's a bargained for proposition in any case that is handled under the framework of Glenn, that we agree not to pursue your personal assets and you agree to assign your rights to us, come together as one. And so I can't imagine a scenario, I know it may be referred to as simply a covenant not to execute in some of the decisions. I can't imagine a scenario in which a plaintiff would ever say, we won't come after your assets for nothing.
What about Key's argument that you don't even need the assignment to execute on a policy of insurance? Is that consistent with your reading of the statute?
Let me think that through. And I do believe that there is case law supportive of that proposition. I think the one that I can think of is Moses v. Halstead, although that's a 10th Circuit case. And in that case, I believe the court said, do you have to have a covenant? Or I believe the question was, do you have to have a covenant? And the court said, well, you don't have to have a covenant. You can have a covenant. You can do it either way. That's how I read Moses v. Halstead. So I do believe that you could execute in garnishment absent a covenant not to execute.
If that's true, what's the consideration then that the plaintiff judgment creditor gets out of an assignment?
Well, I think the consideration in candor is that we have a consent judgment. And that consent judgment's entered. But to answer your Honor's question as it relates to the timing of that consent judgment, that's why we have Glenn, and that's why we had a 3-day trial where they had the opportunity to call every witness that they wanted to come testify as to whether the judgment that was entered was unreasonable or collusive. And they haven't raised that issue. We're not here talking today about whether they committed bad faith. We're not here today to talk about whether the judgment was collusive or unreasonable. They haven't raised those issues because the district court made 61 pages of findings that they don't have a defense on. So now we're at jurisdiction. I think if you boil their argument down here, it essentially asks this court, well, first of all, I don't think that the court can hold for Key in this case and not overturn Glenn v. Fleming, which has been relied upon for 32 years in handling these cases. And I disagree vehemently with counsel with respect to his statement that all of the cases that came thereafter didn't have covenants not to execute or the judgment was entered first. Those cases are cited in our brief, and I won't belabor the issue now. But I think I don't see how the court can hold for Key in this case and not get rid of Glenn. And essentially, and the reason for that is essentially their argument here is what the court overturned in Glenn. In the Court of Appeals in Glenn, they looked at Heinsohn, which was the prior case that said, bad faith claims arise in tort, therefore cannot be assigned. And in the Court of Appeals in Glenn, they said, Glenn is able to try to collect his excess judgment by garnishment, but the existence of the non-liability covenant with the insured nullifies the basis for garnishment. That's exactly the argument that is being made here, and that's what the Court of Appeals said in Glenn. And this court, in the Supreme Court in Glenn, asked several questions. That's been another suggestion that's been made, that even though Glenn decided the issue, Glenn didn't decide the issue. And this court noted in Glenn, the question that was asked was whether a plaintiff who has entered into a covenant not to execute against an insured is precluded from garnishing the insurer in an amount in excess of its policy limits. And the court in Glenn answered that question in the affirmative and laid out a framework for the handling of these cases that established, frankly, a fair procedure to allow the insurance carrier that's being accused of bad faith the opportunity to defend itself in the garnishment action. When there's been several cases, I mean, getting back to what counsel noted with respect to the cases not following the Glenn framework. I can name just a couple of cases. I believe the Granados case that council was involved in a couple years ago, that they didn't raise this jurisdictional issue, followed the Glenn v. Fleming framework. There was a recent case, the name's now escaping me, from the Court of Appeals that has followed this same procedure, and I'll leave it there. I don't think this is a jurisdictional issue. I think it's a defense they should have raised, and they didn't. Even if it is a jurisdictional issue, there's rights retained, there's benefits that he still holds at the time of garnishment that attach.
Okay, can I ask you a question about that?
Yeah.
Because you had said before, I can still, even though I have agreed not to collect against Mercer, Nicholson can still sue Mercer in garnishment. But she would have a defense that, wait a minute, my consideration was that you wouldn't collect against me. But you say, well, you still have a right to garnish Mercer as the judgment debtor. So the garnishment statute says, okay, if you're after earnings, so she clearly has earnings that could be garnished. She has maybe a car, maybe other things, and this key insurance policy. So the defense for her would be, okay, I have this property, and this property, but the garnishment's against property, right? Property of the debtor. Wouldn't her answer have to be, I don't own anything from Key. I got nothing with Key. You have it. So why can you garnish her for something she's already emptied her pockets and given to you?
No, because she's still, that's the issue. They did not convey, we could not, all that was conveyed was the right to bring the claim. He still owes the money to Nicholson, okay? And they owe the money to Nicholson per the plain language of the terms of any liability policy. It's why the Ray case is not on the screws the way that they assert it is. Because the policy of insurance, the key policy says, we will pay for damages for which you become legally liable. We couldn't get that in the assignment.
But isn't that duty now owed to Nicholson? I mean, it's a contract, but it's not a contract that she has anymore. What about it's a shell.
She
What
can't-
about it does
but-
she
but-
have?
But she cannot convey to something to Nicholson which she does not own. She doesn't own the right to be paid anything. The money's always owed to Nicholson. She being Mercer.
But she doesn't own the debt. Nicholson owns the debt. The judgment, that is a debt. Nicholson owns that,
Yes.
right? And Nicholson can collect that debt from Mercer as the judgment debtor. They cannot, so they can garnish her, but they can't garnish property she doesn't own, can they?
I don't think they can garnish property she doesn't own, but the question is, first of all, is it jurisdictional? Okay. And second of all, I believe that she still has an interest, an intangible property interest in the key policy, because Nicholson, by definition, could not have received something that Mercer could not convey, which is the right to be paid under the policy.
How is that a benefit to her? How does it, I mean,
It's absolutely a benefit to Mercer to not have to pay the judgment. I mean, it's a benefit because
that's a benefit that flows between Nicholson and Mercer. That's not a benefit that flows between Key and Mercer. Is Mercer's not going to keep anything. She's a conduit.
Mercer, but that's my point. Mercer liability insurance is different from when we talk about Ray and we talk about underinsured motorist coverage, where it's first party coverage. If something bad happens to me, you will pay me for the bad thing that happened to me. Liability insurance kind of stands for the proposition, the way I always explain it is, if I screw up, they will pay the person that I screwed up the money to take care of me. So that's the right she still retains, is for them to pay it so that she doesn't have to. And she couldn't have conveyed that because she never owned the right to be paid anything. She owned the right for them to take care of it. I see that I am over on my time. Unless the court has any further questions, I will stand down and thank you for your time. And we ask that the Court of Appeals be affirmed. Thank you.
The argument we just heard was that there was, that something wasn't conveyed by assignment because Mercer never owned a right to payment in the first place. This is a wildly circular argument. If Mercer didn't own the right in the first place, sure, that means she could not assign it, because I would agree that someone cannot assign something they don't have. But if it's not Mercer's right, it can't be attached in the garnishment. It's
She
trying.
has a right to enforce the contractual obligation, doesn't she? Doesn't Mercer? Isn't that what she holds here?
She does not hold that anymore because she assigned that right. She assigned the right to sue for breach of contract to Ms. Nicholson.
You assign the choose an action, but the contractual right to indemnity, and I don't know, there may be other first party provisions. I don't know. I haven't read the insurance contract, but the contract itself wasn't assigned, correct?
The contract itself was not assigned.
Insurance contract,
Right.
right? And that contract still, I would presume, requires, if there's a subject to defenses by key, if there's for key to indemnify the insured.
That's right.
And isn't that exactly what's being attached?
No, what's being attached is the cause of action. Or that's what they're attempting to attach, because they come into the garnishment court and they say, here's this cause of action against Key. It becomes ours now. We get to assert it by attaching it in the garnishment. But it was already Ms. Nicholson's to assert. That's the crux of this, is that in a garnishment proceeding, and this is from this court in Ray, in a garnishment proceeding, the creditor takes the place and stands in the shoes of its debtor, taking only what the debtor, could enforce against the third-party garnishee. Ms. Mercer could not enforce this against Key Insurance Company because she'd assigned that right. This court continued in Ray. The plaintiffs, as judgment creditors, cannot recover in garnishment against the garnishee unless the judgment debtor could do so. Under our facts, where Ava Mercer assigned to Ms. Nicholson any and all claims she had against Key, she could not recover against, she being Ms. Mercer, could not recover against Key. According to this court, that means that Ms. Nicholson, as the judgment creditor, cannot recover in garnishment against Key. That's what this court said in Ray. As to whether this is a jurisdictional issue, this court has said it twice, in Ray versus Caudill and in Americold, that when there's no indebtedness to the judgment debtor, the court lacks subject matter jurisdiction in garnishment.
Yeah, given that history, but maybe, oh, I'm sorry, Chief.
Go ahead. No, go ahead.
We've sort of, had some developments in our case law to sort of talk about the origins of subject matter jurisdiction. And it almost sounds to me like your argument, your construction of the statute would mean that they just aren't entitled to relief. It's more like a failure to state a claim. Well, as opposed to the district court never even had jurisdiction to make a determination whether or not there was an assignable or attachable property.
I think the key there is that in garnishment, the subject matter is the property that is attached. And if there is no property that can be attached, there can be no subject matter to support jurisdiction.
Kind of circular. Then you almost have to get to the merits to know whether there's jurisdiction. It's kind of.
I don't think that's necessarily true, Your Honor. I think if there was no assignment, for example, then then we can show that there's no jurisdiction because of the assignment. Because if there is an indebtedness, which means we don't have to get to the merits, it's not an indebtedness to Ava Mercer, it's an indebtedness to Ms. Nicholson. So the question can be answered well before ever reaching the merits of the case.
The question can be answered before reaching the merits of the case if you raise it. What is your response to the argument that you needed to raise this at the time of your answer to the garnishment, not wait till appeal?
My response to that would be simply, Your Honor, that this is a question of subject matter jurisdiction. There is no case that says otherwise. The argument we've heard on behalf of Ms. Nicholson is that, well, there's all these opinions out there and none of them have said there is not jurisdiction. But as we well know, the courts cannot create jurisdiction where none exists. And that's essentially what that argument
Let's
would
assume
do.
we have subject matter jurisdiction. We're here. We have a situation where a garnishment action was filed. The court had the right to adjudicate the garnishment action, which generally means that there's some jurisdiction. It sounds as if, though, what you're saying is that the court didn't properly adjudicate the garnishment action because there was no basis for a claim, no standing. Granted, standing can be jurisdictional, but just assume we have jurisdiction. Does your whole case fall if we determine there is subject matter jurisdiction?
If the court determines that there is subject matter jurisdiction, then I mean, that's the issue I'm asking the court to decide in our favor. So if the assumption is you've decided against me, then I probably walk away the loser here today. But certainly there were other aspects of this case that Key thought were decided in error. The denial of a jury trial at various stages on various issues, but that's not the thrust of what we're arguing today. It is that there is no subject matter jurisdiction. The district court did not have subject matter jurisdiction. And so its adjudication, however that went, was without authority, without jurisdiction, and void. And for that reason, we'd ask this court to reverse the decision.
But it would have had jurisdiction to enter a finding that there was no property to attach under your theory? It seems like if there's either jurisdiction or there's not. And the question is whether there's property to attach, which I mean, did the court have jurisdiction to make the determination that there was or was not property to attach?
I think as part of a determination as to whether there's subject matter jurisdiction, I think a court is not only has the power to, but is essentially required to determine if it has subject matter jurisdiction in any case, and that will, depending on the circumstances.
Well, that's my question here. Did the district court in the garnishment proceeding have jurisdiction to decide whether or not there was attachable property?
I think we're conflating words. I think the court, if the district court decided I have subject matter jurisdiction, it can do that, but I think that's wrong. I think that decision that it had subject matter jurisdiction is wrong. And if it did not have subject matter jurisdiction, then anything else that it decided is void.
And you think it's wrong because there wasn't attachable property?
That's right.
I have a question. If whatever happens here and it hypothetically that we have Nicholson sue Mercer, under, I don't have the contract in front of me, but the insurance contract between Key and Mercer, would Key still have a duty to defend Mercer? Is that one of the sticks, as Justice Wilson said, that is still in her bundle?
I suppose that there would never be a suit against Mercer at this point because the suit against Mercer has already been reduced to judgment. But let's assuming at this point there's been an assignment and there was a suit against Mercer. I haven't looked into that issue of whether there would be a duty to defend. And I think it gets complicated because maybe let's assume hypothetically there is a duty to defend. The problem from a jurisdictional standpoint is that Ava Mercer, even if that duty were to be breached, could not sue for breach of that duty. only Ms. Nicholson could sue for breach of that duty because.
No, what I'm saying is that, if Key doesn't pay, okay, and so Nicholson decides, well, I'm gonna go after Mercer for everything she has. Forget this thing that we signed. You know, regardless of whether there's a good defense for Mercer, maybe she would prevail, okay? But she's gonna have to hire a lawyer, right?
I suppose she would have that choice and it would be a good decision probably.
Right? And so does Key pay for that lawyer?
Your Honor, I do not know the answer to that question. The question you're asking essentially is, once a judgment has been obtained against an insured person, does the duty to defend apply to an effort to execute on that judgment? And quite frankly, I don't know the answer to that question. I don't think it gets to our issue today, but I don't know. I have not looked at that question. I tend to think probably not, because an execution is not a suit that seeks damages for bodily injury, which is typically what an insurance policy covers. So if I'm going to go out on a limb and say something here, that's what it would be. But I have not looked into whether the duty to defend specifically applies to execution. Justice Standridge, I did find the citation to that Curo Enterprises case.
Oh, I found it.
You did find it? Okay. All
I
right.
spelled it, yeah. Yeah.
She's,
Thank you.
All right.
though.
All right. Thank you very much.
all right. Any other questions? Court will then take this matter under advisement. We thank both counsel for your arguments today. Court is now in recess until 9 a.m. tomorrow morning.